role it plays, would you accept that that view is held by the leadership of the NPA?
I would not like to speak on behalf of the leadership or individuals of the leadership. I think it would be unfair for me to try and say what they think and feel and do. But I really hope that they all feel the same way.
Fair enough. Would you accept that Advocate Jiba has got a commendable amount of experience as a prosecutor?
Yes, she has. Look, I met her in 1999 when I joined the SCCU, founding member of the SCCU. She was then attached to the office for, I think it's called the Office for Serious Economic Offences. Advocate Jan Swanepoel SC was the head there. And they worked on very big commercial matters. Thereafter, she went to the DSO. I lost contact with her. And on her return, she became a deputy at the SCCU again, somewhere in 2010, 2011, I'm not sure.
So you would accept that her rise from the time that you saw her and her rise to the ranks of the Deputy National Director of Public Prosecution was based entirely on merit?
Look, when I met her, I think she was already appointed as a Deputy Director, so I had no knowledge of her history prior to becoming a Deputy Director at the Office for Serious Economic Offences. And like I say, shortly thereafter, I'm not sure when, we were together for about 2 or 3 years, and then they became the DSO, and we remained behind. So I have very little personal knowledge about her history prior to me meeting her or after she left to become a member of the DSO. I don't have a lot of personal information about her history.
Fair enough. She shares the views that you expressed about the importance of the NPA and its image. You would accept that's the position?
I would accept that.
Right. Now, I want to ask you some questions relating to the memorandum that you addressed to not just her, but to you copied to Mkhwebi, Ramaite, Hofmeyer, Advocate Mokatla, and Nzinyati. You recall that memorandum?
That's correct, yes.
It's on page 111.
That is correct, yeah.
Right. You testify that the purpose for this memorandum was to request Advocate Jiba to review the decision of Mkhwebi.
That is correct. I think in the introductory paragraphs of the memo we set out the purpose of the memo and what we really want, and then I think in the concluding paragraphs we again explain why we're writing this memo and what we want to try and achieve with it.
Right. What is a bit concerning for me, following on what you've just said, can you explain to the panel why it was necessary for you to address this memorandum, which you intended to have, which you intended that Advocate Jiba would make a decision on, why you addressed it to Dr. Ramaite, Hofmeyer, Advocate Motlala, and Advocate Mzinyati? Were they necessary people for what you intended the memorandum to achieve?
I'm not sure about the words were they necessary, but you must remember that Advocate Mzinyati was the DPP and he was involved in the process. That's why we copied him in. Advocate Mkhwebi was obviously the special director and it was his decision. That's why he was copied in. And the others are all members of EXCO, of the NPA. I can't now, as I sit here, say precisely or think and remember precisely why we included them, but they are members of the EXCO, so they are senior people, and we thought it's, I can't remember exactly why we included them, but we did include them. Whether they ever received it is another story, I don't know.
No, we know that you handed the copy of this memorandum to Advocate Hofmeyer.
Yes, to him, but I don't know if the others ever received their copies.
Now, but what is a little of a concern, I don't want to make much of it, except to point out that if your intention was a good faith attempt to upset a decision that you felt strongly about, and you knew who the decision maker was, copying all these people in that memorandum was probably not, I'll pitch it at saying not necessary, because they are not decision makers at all.
Well, they are part of the top structure, and they all were deputy national directors. So we believe that for some other reason, which I can't remember plainly now, it was important that the exco of the NPA consider the facts given in the memo.
But so you won't say it in positive terms. Let me put it in positive terms. Advocate Tiba was the only decision maker from whom you wish to have a decision, right?
Yes. And whether she would want to do the decision in consultation with the exco, we wouldn't know. But yeah, the fact is we included them, and yeah.
We
May I all just say, this is also, it was a very unusual step. I mean, I don't know of a step like this previously, and I don't know about a step like this since. So there's no rules or guidelines that you can follow and say, but this is the correct procedure or not the correct procedure. We were here on uncharted territory.
I'm glad to say that. I'm glad to say that, because the next question I'm going to ask you is would your view extend to the response that you complain of? The fact that this was an uncharted territory, this was new, this was unprecedented, would it extend to saying, well, if Advocate Jiba decided to respond the way she did, that also was consistent with the fact that this was uncharted territory?
Well, I don't know what you mean that she responded in the way she did.
Let me explain to you. Advocate Jiba responded to this memorandum by informing Mokgoro.
Sorry, I don't know what she informed Advocate Mokgoro.
Yes, I'm telling you.
Oh, yeah, no, I'm unaware of any of that.
Yes.
We expected a response from her because it was addressed to her, even if it was just a one-liner coming back saying, look, I thought about it and I'm not going to do anything, or you don't have locus standi to address me in this issue, or we thought we would receive some response, even if it was just as a courtesy.
Yes, and may I just find out, did you, a week after sending this memorandum to Advocate Jiba, send an email asking her to respond?
No, we didn't.
Did you
the first one that I sent, but it was not directly to her, it is on page 134A of the papers. It's an internal memorandum that I sent to the then acting Special Director, Advocate Naomi Humphreys, or rather Advocate Mualusi did. He was then acting head of our office. It's dated 29 August 2012, and in this memo, page 3, we say, I am informed by Advocate Ferreira that this office has never received any response from the acting NDPP Advocate Jiba regarding this memo.
Right.
So this is the only memo, or the only letter of correspondence. I didn't write another email and asked her what the decision was.
Are you aware of any inquiries made by your co-author, Advocate Breitenbacher,
Now, you
in
must
which she
remember,
sought a response to this from Advocate Jiba on this memorandum?
Now you must remember, shortly after this memo, 7 days or 6 days after this memo was handed to Advocate Jiba, well, to the NPA, and Advocate Mokgoro, Advocate Jiba, Advocate Glynis Breitenbach was suspended.
Right.
And she was marched out of the office at 228 Versaghi Street, and the office was locked. And we had no further communication then. So, yeah, I don't think she could have at that stage, because she was suspended. And I think she was suspended, if she was suspended, she couldn't fulfill any functions or official functions.
But your big complaint against Advocate Jiba,
you referred to an email or something. You didn't say what page it is.
It's 134A. It's the second 134A. It's an internal memorandum dated 29th August 2012, and it's from Advocate Malusi to Advocate N. Humphreys.
Can I, while we're at it, request that this file is a disaster, if you could please. I don't know how many 134As, so it's really not very helpful. But yeah, please continue. Sorry about that.
Thank you. So, from the time that you handed up a memorandum expressing very strong views about a decision that very strong views about a matter that you felt strongly about, you did not address any email, any letter, or pick up a phone call to find out from Advocate Chiba whether a decision has been made. Is I correct to say that?
That is correct, but you must
Thank you.
also remember that shortly after that, I think the review application by full came in, so that overtook any events that may have happened.
Why is the FUL application relevant to the question I just asked you?
Well, they wanted to review the exact same decision, and court papers were exchanged, etc., etc., so I thought at that stage it's now a thing between the NDPP and FUL. Yeah.
But your complaint was that you had not been told what the outcome was. And
Yes.
the decision maker or the functionary that had to tell you or to report back to you on your memorandum was Advocate Chiba. It was not FUL, it was not the court, it was Advocate Chiba. You did not address any communication of any nature to Advocate Chiba to prompt her to respond to you, did you?
No.
That's the answer I want. And then perhaps just to ask you, or maybe let me put it to you that Advocate Chiba did respond to this memorandum, and she responded to Advocate Mokgoro by discussing it with Advocate Mokgoro, and a decision was made arising out of that discussion.
Yes, I'm unaware of that.
And then let's perhaps the second issue that you have given evidence on relates to the prosecution of Advocate Chiba by yourself.
That is correct. Myself and Advocate van Eden.
Yes. Now, I want to perhaps just look through a memorandum that was part of what you wrote, a legal opinion on the prosecution of Advocate Chiba. I had a moment of brilliance, and I managed to get it through my computer, which is on the Dropbox. So it's okay. Now that brilliance is. So it's folder J, point 25. Folder J, yeah, it's item 25. That's the legal opinion that Advocate Ferreira addressed to the then National Director of Public Prosecution, Mr. Sean Abrams. But before I ask you a question on this, can I just ask, do you have any vendetta, any personal, any professional dislike of Advocate Chiba?
No, not at all.
You respect her as a professional?
Yes.
Thank you. Now, this memorandum that you drafted, there are a couple of things that are of concern which I want to take you through. What was the scope of your...
We don't have it in hard copy.
I don't think that it is in the file in hard copy.
Oh, okay.
Do you have that document, Advocate?
Chairperson, I am familiar with the document, and I'm willing to answer questions even though I don't have it in front of me.
It's not satisfactory, and I accept. It would have been better. I think, yes, that would help. Thank you.
So what you want to do is confirm that it's the right one. It is.
It is the memo of 5 August, is that the right
Yes,
one?
that's the right one.
Okay.
I hope Mr. Ferreira is better than me when it comes to operating these things. Yeah. Yes. It's 5 August 2015. The 5th of August 2015. Mr. Ferreira, Advocate Ferreira, just briefly, what was the scope, what was this precise instruction that formed the basis of this legal opinion? What were you asked to give an opinion on?
We met the NDPP Advocate Abrams on 22 July. We made a presentation to him and we informed him about the prosecution and among other things. At the end of that meeting, he asked us for a legal opinion involving the case against Advocate Jiba. That was his words. Please provide him with a legal opinion. There was no specific further instruction. It was just providing me with a legal opinion about the prosecution of Advocate Jiba.
Right.
So it was a very broad statement.
Right. So, but what would you have been? What was your understanding of that instruction in terms of the issues that you traverse in that legal opinion?
We had to motivate why we believe that there's a case to be made out against her and why the prosecution should continue.
Right. Thank you. So, can I continue? Yeah. So, paragraph 5 of that opinion.
Yeah, that's the documentation that we presented on the meeting of 22 July. And after doing all of that, the NDPP asked for a legal opinion.
And is that the material that you considered for the purpose of your legal opinion?
No, for purpose of a legal opinion, I was provided with the 23 dockets, KZN dockets in the prosecution of General Boyson, in soft copy, as it was discovered to him, and I was provided with all of these documents as well. And you must remember there was actual case docket open and registered, and that case docket had a number of statements in it. So this is all material. It's not only this material that was looked at.
So you did consider what was in the docket?
Yeah, you must remember it's firstly the docket against Advocate Jiba, and then the docket against General Boyson, or the dockets against General Boyson.
Right. Now, just for the moment, let's focus on what was in the dockets of Advocate Boyson. Sorry, General Boyson. Would you tell the panel what you saw in that docket?
Look, it's 23 different dockets.
Right.
And those 23 different dockets is like a normal murder investigation docket of the police. There's the witness statements, there's chain evidence for inquest that was held or post-mortems that was held, etc., etc. So it's a normal murder docket, but 23 of them.
But would you say that that the charges against General Boyson were very serious charges?
They were serious. Racketeering is a serious charge, and murder as well.
Right. And as far as murder is concerned, there are a number of people who were murdered that were the subject of the prosecution, or rather the object of the prosecution.
There's a number of people who died. Whether they were murdered was for the court to decide eventually.
I'm glad you say that, because given that the court has not decided on that, you had an opportunity to look at this docket and to form prima facie views on the docket. What we can say with certainty is that there are people who died.
That is correct, yes.
There were investigations carried out by the police.
That is correct, yes.
There were statements obtained by the police.
Yes, and in some instances, inquests were held.
Inquests were held.
Finalized by a judicial officer.
prosecutors looked at the docket and formed the view that General Boysen should be prosecuted.
On certain of the charges is true, because you must remember initially certain prosecutors would have looked at the dockets and decided to nolly them, and an inquest would be held and a magistrate would make a finding that the police act in self-defense, and some of those dockets also formed part of the material that new prosecutors then used to decide to prosecute about 28 people or 23 people, including General Boysen.
As a prosecutor is concerned about who would like the NPA to be an effective institution that is trusted. That more than 10 people were killed, were dead, and someone had to be held liable for it, right?
If legally somebody had to be held liable, yeah, because if the police acted in self-defense in a shootout with a criminal, then the police would not be responsible, the death would be finalized as an inquest, and everybody would be happy.
Except those that are dead are not happy, yes. The question I'm really wanting you to consider is that somebody in your position, with your passion, with your experience, had looked at these documents and formed the view that General Boysen and others ought to be held liable for the death of many people in KZN. Would you agree with that?
Other prosecutors formed that opinion. Now,
Right.
me personally didn't do so.
Yes. And so we have your views and the views of other prosecutors, right?
That is correct, yes.
And that's perfectly healthy.
That is correct, yeah.
Right at the end of my cross-examination, I want to ask your views on prosecutorial independence. And you can just keep it in your mind at the end of what I'm going to ask you, and why it is important to have that principle as a constitutional principle. In giving your opinion to the NDPP, I just want to refer you to certain paragraphs of your opinion which I found fairly concerning and reflective of a prosecutor who had prejudged pretty much the outcome of these very serious charges that General Boysen was facing. The first one is a statement you make in paragraph 20. In paragraph 20 you say, in one or two prosecutorial memos, it is noted that Boysen will allege that he had not been on the scene of the crime, save for 2 instances where he arrived after the event. It is evident at a reading of the various dockets that there is no direct evidence linking him to the individual offenses in these dockets as purported by Ms. Jiba.
That is correct, yes.
Would you not have wanted to have the court determine on the basis of what the 2 prosecutorial memos suggested? Would you not have wanted the court to decide whether in fact the prosecution of General Boysen was justified?
I think one must just take a step back. What I had to decide was a criminal docket that was investigated, in which there was an allegations that Advocate Jiba perjured herself. And there was findings made by Justice Gorvin in KwaZulu-Natal. That was what prompted the whole investigation, and that was what I was looking at. If I could prevent myself from looking at the KwaZulu-Natal dockets at all, I would have loved not to have looked at them. But the problem is I couldn't look at the court papers in isolation, because the court papers that served before Justice Gorvin included Advocate Jiba saying that she made certain decisions based on the court dockets, and therefore I had to look at those court dockets. And It's easy to say you must leave it to a court eventually to decide, but if, like Justice Gorvin has said, there was no rationality to prosecute Boyson because there was simply no evidence against Boyson. One can't take a person to court just so that the court can decide whether they're guilty or not. You at least have to have a prima facie case, and you have to at least substantiate. And in terms of the prosecution policy, you must look at the victim, but you must also look at the accused, and you must look at society. And it's not in the interest of the prosecuting authority to prosecute people where there's no evidence to substantiate the conviction or possible conviction.
The problem is this. I don't think that you have read the judgment of Govan correctly, because Judge Govan did not say that there was no evidence on which to prosecute General Boyson.
On which to issue the racketeering authorizations, he said that.
Yes, but he did not say that there was no evidence, which is what you said earlier, on which to prosecute General Boyson.
Linking him to the racketeering offenses, that is clear.
And then, and of course, just keep in mind the purpose for which you are writing this memorandum. And so the reason why I'm flagging out this paragraph is because I want to argue at the end of it all that you went way far beyond simply providing a legal opinion on whether or not there were perjury charges. You almost went into the defense of General Boyson.
No, I don't think I went to his defense. What I had to do is to make out what case there is against Mrs. Jiba, of Advocate Jiba. And the problem was it was intertwined with the prosecution against Boyson. You couldn't look at the one in isolation. Unfortunately, you had to look at both. Otherwise, you would not have been doing a proper job.
And then if you look at paragraph 21, and then you say certain problems that may be relevant to all the accused, but that are certainly relevant to Boyson. Again, you're looking at Boyson, is the following. In the following counts, positive premier residue were found on the hands of the deceased, and you mentioned the deceased people that are involved. Based on that, you then say, it is uncertain how the prosecuting team, that's paragraph 22, it is uncertain how the prosecution team in the Katomana prosecution team intends to get past the evidence that prima residue were found on the hands of the deceased listed above, unless they possess evidence that this evidence was manipulated or that it is false. We have not seen such evidence. If such evidence exists, it certainly has not been disclosed to Boyson at this stage. Now, would you accept that that statement was quite strongly in favor of Boyson?
The findings made by Judge Gorvin was limited to Boyson, not the other accused. So that's why I focused on Boyson as well and not the other accused.
No.
And that's why I say here it may be relevant to all the accused, but my task is to look at the judgment of Judge Gorvin and focus on what evidence was available against Boyson. Now, perhaps I must wait if you have a question, because otherwise I'm going to anticipate what you want to ask. But because why this is very important is there is no direct evidence against Boyson. There is 2 statements or 3 statements in the docket linking him to coming to a scene at the end of a shooting. So he wasn't involved in the shooting himself, and he only comes to the scene afterwards. So in that regard, it was therefore very important what evidence is there to link him to racketeering and or to the actual murder charges. Now, it was said by Advocate Jiba and per se by the prosecution team that Boyson reasonably ought to have known that the Cato Manor Serious and Violent Crime Unit were killing people, and they were killing them for financial gain. And the guilt of Boyson is based on the fact that he was the officer in charge of Cato Manor. So therefore he must know that his people is illegally killing people for monetary gain. So now you must look at what evidence is there. And that's why we looked at that, because primary residue, and I haven't been a prosecutor in a murder case for very long, well, since 1999, but going on my memory, primary residue is something that don't stay on the hand of a person who fires a gun for very long. You can wipe it off easily on clothes, and you can also wash your hands. So in all of these cases, you must remember the defense of the police is they acted in self-defense. So you have to be able to counter that. Now, if they say the deceased fired shots at them and there's positive primary residue on the hands of the deceased, Boyson, who was not at the scene of the crime, would be entitled to look at that and say, but my men say they acted in self-defense, and there are support for that, because there's primary residue on the hands of the deceased.
Except for all that you have said, what the position that you took would have prevented General Boyson from offering that defense. Because from the position you took, the person who had authorized the prosecution of General Boyson is now facing criminal charges of perjury and fraud in relation to that decision.
Sorry, but I don't know how that would prevent General Boyson from taking that offense.
Because, and this is where, that's where you and I perhaps are going to play the dance. General Boyson.
Please ask your questions in such a way that you don't play the dance.
Yes, no, I will. I'm trying my best to keep it rhythmical. General Boyson was at the time facing serious charges. You agree with that?
He still is.
He still is.
Yes.
Now, the prosecutor who authorized his prosecution is facing criminal charges in relation to what she says she considered when she authorized that prosecution. You understand that?
I do.
Now, is it desirable for a prosecutor to ever be faced with a situation where they face criminal charges for a prosecutorial decision they have taken that someone must be charged? Is it ever desirable?
Well, not that it's desirable, but if the prosecutors take the decision correctly and they do not commit perjury, then they don't face possible perjury charges or not. You must remember that a lot of times civil litigation is engaged in people saying that there was a malicious prosecution.
Yes,
and it happens at the same time that there's possibly a prosecution on the go. So the accused believes that there's a malicious prosecution, and he tries to prevent the trial from taking place. So.
No, I have no difficulty with an accused taking a position like that, because they are entitled to do so. The proposition I'm putting to you is a position of principle. Is it desirable that a prosecutor who must take decision in the interest of ensuring that criminals fear the prosecution and the public trust the NPA, is it desirable that they face charges of what they say they considered in order to come to the conclusion that a criminal prosecution ought to proceed?
Let's look at it at the basis as follows. If, and except for
Can you
one,
just answer my question at the level of principle?
But that's what I want to try to do. If the prosecutor had absolutely no reason to prosecute, for our sake of argument, say the charges that we preferred against Advocate Jiba was true, and we could prove it, then it's certainly desirable that a person should be prosecuted, because if you commit a crime, you should be prosecuted. I mean, nobody is free from committing crime and not facing the consequences, not even a prosecutor. If I commit a crime, the fact that I'm a prosecutor can't say that now I can't be prosecuted.
Because the evidence leader must go, I will move quickly.
Mr. Masuku, I'll change the flight if you need to do it. But, I mean, don't use me as a fall guy for this.
And then, sorry, Chair, I'm trying to I'm trying to go to a paragraph that will probably cut off all the other paragraphs I intended to ask. Oh, you see. And then, of course, from paragraph 50, then you do your evaluation, having done all the analysis of having set out your facts. Then you do an evaluation of your facts. And then in 56, you say it is of fundamental importance to our democracy. 56 of 56, it says. It is of fundamental importance to our democracy that an institution such as the NPA, which is integral to the rule of law, act in a manner consistent with constitutional prescripts and within powers as set out in the National Prosecuting Authority. Then 57, you say, in this matter, it is vital to note that when deciding to prosecute Major General Boyson, the then acting NDPP, Ms. Jiba, had to take cognizance of the fact that the decision to prosecute Boyson may affect him, his family, the victims, law enforcement agencies, and the public. She was required to act fairly towards accused Boyson and should have dedicated herself to the achievement of justice. How does that support your decision to prosecute? Or your advice in the legal opinion that a prosecution is warranted?
I quote there from a case, and that is one of the things that one must look at. I mean, surely you can't say that if that you would like yourself or your own family to be subjected to a prosecution where there's absolutely no evidence against you.
No. Are you suggesting that there's absolutely no evidence against General Boyson?
That is what I'm suggesting, based on what I read and based on what is in my report.
But you know and accept that there are other prosecutors who have looked exactly at what you have looked at and come to the different conclusion.
Yes, I have, but the only thing I have is there two prosecutorial memos, and like I say in here, the two prosecutorial memos that was looked at by Advocate Jiba does not precede the evidence that they're going to use against Boyson. There's no list of evidence. What factors are they going to argue to prove Boyson's guilt? And as a prosecutor, I looked at it, and I said it out in the memo, and I don't want to put it stronger as in the memo, there is no evidence against him.
So your view, as you sit right where you're sitting now, is that General Boyson, there's no evidence against General Boyson? Or are you saying at the time you wrote the opinion, there was no evidence against General Boyson?
At the time I write the opinion, I don't know if new evidence has come to light in the meantime.
Now, of course, the next sentence, the next paragraph, paragraph 58, raises a bit more concerns. It is, you say, it is safe to say that there was pressure on Ms. Jiba to prosecute Boyson. Can you just help us understand that pressure?
I think somewhere in the memo I deal with it, Advocate Simpiwe Molotshu, the acting DPP for KZN at that time, describes in an affidavit that's in the docket that he got a phone call from Advocate Jiba who said to him that there's a case that because of pressure had to be enrolled urgently. And he then informed her, no, there's no such thing as urgently enrolling cases. If you've got a case, give me the docket, give me the memo, and I'll make a decision. He was referring to this specific case. And then later on, he was given an indictment and asked to sign the indictment. He refused to sign the indictment without a prosecutorial memo. And I don't want to go into all the detail because there may be other witnesses with more fresh memory about that than me. But then what eventually happened is he was from there on discarded, and prosecutors from Johannesburg took over the matter and proceeded with it. So that statement is based on what Advocate Molotshu states.
Okay.
He received a telephone call and he was informed that there was pressure on Advocate Jiba to enroll basically the Boyson matter, although the name Boyson wasn't mentioned.
But Advocate Ferreira, can you perhaps what you just said is not entirely correct. From in trying to explain the pressure, you've gone outside what you yourself wrote in your memo. You just read the next paragraphs that you wrote, or let me read them for you. He was subsequently suspended by the SAPS, that is General Boyson. He was a vital witness against Wan Modie and Pandai, people with political influence. That's you writing that. Mr. Nazim Kasim, SC, indeed found that there was an agenda on the side of the SAPS to get rid of Boyson. You see that?
That is correct, yes. And if you read the judgment by Nasir Kasim SC, you would see, and I think I quote from the judgment, that he found that there was a political agenda to get rid of Boyson from the police.
So just so I get this off my mind, it's bothering me. Is it your view that Advocate G was influenced, was under political pressure of the nature you describe in that paragraph for this prosecution to proceed?
I don't know what pressure, because she was the one that had the telephone conversation with Simpiwe Molocho and spoke about pressure that's on her to enroll the case. I don't know what pressure it is. But from the police's side, I know that there was police that wanted to get rid of Boyson, and that is in the judgment by Nazir Kasim SC.
So if we can take it to its logical conclusion, I mean, you put Advocate Jiba in the middle of this pressure. You're suggesting that when she signed that authorization to prosecute General Boyson, she was fitting into this agenda to get rid of General Boyson.
No, I'm not saying that she's part of this agenda. All I'm saying is that I was informed under oath by Advocate Molochwa that there was pressure on her from, I don't know from where, to enroll the matter. Obviously, she would know if there was pressure like that, and if there was pressure from where hence it came, or she would be able to say, but no, Advocate Molochwa was mistaken or he's lying. And there's never been any allegation that Advocate Simpiwe Molochwa was lying in that affidavit.
If you look at paragraph 61, you say Ms. Jiba had no evidence under oath before her on which she could lawfully authorize the racketeering prosecution against Boyson.
Yes. At that stage, when I write the memo, it was quite clear. Because, and perhaps I can explain, because of the fact that you would not find Boyson on any of the scenes during the shooting, and because of the nature of racketeering, and you now want to prove that the police unit, the legitimate police unit, is actually a racketeering enterprise, you would now have to prove that they were doing unlawful acts, and that Boyson not only know about those unlawful acts, but that he went along with it. Now, the problem that we have is earlier in the memo, we explicitly say that there was people that died, inquests were held, and magistrates made findings that the police acted in self-defense. And then you have this, the whole story about the primary residue. Now, what I'm saying is, if that's the evidence that's on record, Boyson would be completely correct to say, but there's no evidence that my personnel or the personnel of that unit is unlawfully killing people. And if you can't prove that there's some form of evidence to inform him that his men is actually acting illegally, there is no evidence under oath with which you can prosecute him for racketeering.
That's a very... So you say, if for purposes of advising the National Director of Public Prosecution on the charges of perjury, it would have been necessary for you to go as far as saying that there was no evidence against General Boyson on which to prosecute.
It was not necessary to go that far, but in a certain sense, but that's what I found when I did the investigation. And I mean, there was no reason, most certainly not to hide this fact from the National Director, or not put that fact in here, when I clearly believed that it was an important fact for him to take notice of.
Can I just perhaps read what Judge Govan found which is not as strongly as you suggest he did, the judgment of Govan, I'm not sure where in the system it is. I've got it in a copy, but I can just read it I'll read it into the record. In paragraph 38, do you have it?
Mr. Masuku, for the record, will you cite the judgment
Yes.
fully?
No, you can read it. I'll listen. I don't have a copy with me, but
We just need the citation.
It's folder A and it's in the bundle, it's folder A and it's number, sorry, it's folder B number 1.
I'm struggling to find the citation. Can I come back to that? Oh, okay. Yes, that looks like that's the one. Yes, the only problem is I wish it was cited in the way I normally I'm used to the citation. So in that case, it says
Can I help you?
yes.
Maybe I can assist my colleague Boyson versus Acting National Director of Public Prosecution and others, 2014-2, all SA 391 KZT.
I was under pressure. I would have found it anyway. So paragraph 38. Justice Govan says, I hasten to emphasize that this outcome is based purely on the facts of the present case. It does not provide a basis for opening the floodgates to applications to review and set aside decision to issue authorizations to prosecute under Section 2.4 of POCA. If the respondents, not just the respondent, had properly understood the principle of legality, it seems to me that their responses to demands for documents or reasons might have been different. And then if you go further down, the sentence that starts with, had she outlined even in basic terms what these documents and information comprised, said that she had relied on them and shown that they had included information linking Mr. Boyson to the offenses in question, this application might not have seen the day of light. But perhaps a principle that I want us to live with is further down. I think it's line 40. It says, in the light of the provisions of POCA, it is not necessary to have before her sworn statements from witnesses on which the state intends to rely. And that doesn't answer the question whether or not she had committed perjury. That's the point. But I'm saying, just for the purpose of assessing whether or not she had committed perjury, you would have had to appreciate this legal position, that she didn't have to have all the information, right?
Yes, but in the prosecutorial memos, it should have been put out to her what evidence there is to link Boyson, and based on that information, she had to make a decision. She was obviously in a difficult position because I'm not sure whether she actually read all 23 dockets, most probably not, and she had to rely to a large extent on 2 prosecutorial memos setting out what the case is about and why racketeering authorization must be granted by her. Now, I would want to challenge you, I don't know if it's in the dockets or in the papers, but you read the 2 prosecutorial memos and you then can inform the panel what linkages are there in those 2 prosecutorial memos linking to the racketeering authorization for Boyson.
You see, the panel is not tasked with making such links, so I will decline your invitation. Can I just maybe the judgment of Lehoti? Obviously, this opinion was written by you prior to the outcome of the GCP application. Am I correct?
You mean the striking off application?
No, yes.
Yeah.
When you wrote this affidavit?
Yeah, I believe so.
Okay. The judgment, just want to refer you to the judgment of Lehodi, Justice Lehodi. Maybe.
Paragraph
Oh, they've got it.
51 most probably, no.
No, don't presume that I want to go there. I just want to be sure that it is the correct one, but I need to enlist the assistance of my colleague on the actual citation for the record.
Previously quite impressed, Mr. Masuku, when you started off. You boasted about...
I've run out of fingers.
It's the General Council of the Bar of South Africa versus Jiba and others 2017 to SA 122 GP.
And may I just refer, thank you, Ms. Advocate Power. In paragraph 67 of that judgment, it reads, I cannot find any malafides or any or ulterior motive in the authorization by Jiba as contemplated in POCA. POCA is like a cry out loud for declaration of war against serious, continuous, and organized crimes that needs specialized investigation and prosecution. Most importantly, POCA requires the freedom and space to be given to members of the prosecuting authority in the exercise of their legislative power to investigate through members of their investigating directorate and under the watchful eye of the special director, so appointed to prosecute without fear, favor, and prejudice those implicated in the commission of serious crimes. Anything short of this, or anything which tends to impede on this constitutional and legislative imperative, for example, hauling Jiba to the proceedings in terms of Section 7 of the Admission of Advocates Act, ought to be based on very cogent, serious, and exceptional circumstances. That principle is very sound. You accept that?
Yes, it is.
Now, if you were faced with that principle at the time that you considered whether or not there was an intention to mislead, an intention to commit perjury, would your opinion still be the same?
Yes, based on the documents I had before me at the time, I would say yes, because if you look at paragraph 51 of the same judgment, and I don't know to what extent, if they can just scroll to 51, I don't know to what extent that influenced the judge in making the remarks that he did here. But you see there, having regard to what is quoted above, it does not seem that the statement Jiba says that they are all statements under oath is correct. Nowhere in Jiba's answering affidavit did she make such a statement, neither did she say any of the annexures NJ 2, 3, 4, 5 were under oath. Now, if I take you to her affidavit in that same, but you don't have to go to affidavit because I quote it in my memo. In my memo, I quote paragraph 24.5 of her answering affidavit. And the second sentence of her answering affidavit reads as follows. He is directly implicated under oath in the statements placed before me in annexure NJ 2 to annexure NJ 5. Now, to my mind, two things come out of that statement. Firstly, General Boyson, that's the he she's referring to, is implicated in those four statements, and secondly, those four statements are under oath. And I think, I don't know what papers was before Judge Lehodi, but to my mind, paragraph 24.5 of her affidavit clearly states that those four annexes are under oath.
So, but you...
And that they link Boyson to the racketeering charges.
So your answer to my question is that despite what paragraph 61 says, you would still have charged Advocate Jiba with perjury.
Yes, because the problem is paragraph 51 of the judgment of Justice Lehodi. I'm not sure what role the fact that he was not being alerted to paragraph 24.5 of her statement, what role that played. Because had he been properly advised about 24.5, he would not have made the remark in 51, because clearly paragraph 24.5 of her answering affidavit states that those four annexes are not only under oath, but that they implicate Boyson in the commission of the offences for which he is charged.
But can I go back to the opinion and refer you to paragraph 73?
Sorry, this computer has unfortunately gone off, and but if you have it there, I can follow. Sorry, I can follow there on the screen.
In fact, perhaps starting off at 72, you say the elements, and this isn't dealing with perjury, are unlawfulness, false statement under oath in the course of judicial proceedings, and intent. If any of those are missing, would it constitute perjury still?
No, obviously you have to prove all four of those
Right.
elements.
Now, in 73, you say, again, in this case of Miss Chiba, and not Advocate Chiba, in this case of Miss Chiba, the only element that may be in dispute is intent.
That's correct, and I think if you read the opinion and you look at the evidence that's available, you will agree with me that the only thing that the state may have found difficult is intent. The other elements, that it was under oath, that it was in course of judicial proceedings, that it was a false statement, and that it could constitute unlawfulness, that was fine. The only possible problem we would have faced is whether she had the intent, dolus eventualis, dolus directus, or not. In other words, did she make these statements which is false negligently, or did she make it intentionally?
So which one would support your thesis of prosecution?
Well, you have to prove intent, but you must remember, you're not going to get an eyewitness to come to court to say that person had the intent. The court looks at all the facts, including the witnesses and the cross-examination, before the court comes to a finding that the court can find there was intent and in what form the intent was. Now, if you look at paragraph 75, if an untruth is uttered on a matter of deep significance or unforgettable materiality, it may be inferred that it was uttered deliberately. And if you go further, it will say with the actual intent, or with, in the proper case, recklessly, i.e. with legal intent.
So the deep significance or unforgettable materiality here is the fact that Boyson was involved.
No.
What is it?
There's the four statements, only four statements, which she must read, and she attaches it to her affidavit. And in that four statements that she attaches to her affidavit before the proceedings before Justice Gorman, she says Boyson, he is directly implicated under oath in these statements placed before her. So, two questions. If you read those four statements, you must then be able to see clearly, as she alleged she did, that Boyson is implicated. That's the first question. Second question is then that those statements are under oath. And unfortunately, on both scores, she's wrong. It is false. As I described in the memo. In the memo, we deal with all four affidavits, and not all four of them were under oath, and not all four of them was commissioned or signed by the time she took her decision. And then, more importantly, is that I would dare you to read those four statements and say how Boyson is implicated in those four statements to the crimes in the indictment.
Perhaps, in fairness to the panel and the general proceedings, at the end of these proceedings, when we have to make submissions before the panel, we will argue that you will argue that there are other contrary views expressed by prosecutors in other circumstances more senior to you that are different, that reach a different conclusion to the evidence that you've given in relation to the prosecution of Advocate Chiba.
Okay, I haven't seen their opinions, so I haven't seen how they motivate it, and I haven't seen the arguments they make out for it, so I won't be able to comment.
Can I just I'm trying to figure out exactly where the statement of Gladstone Selo Maema is in the it's number 88 in folder J. Just go up. There's also Mahatla who also considered his opinion. What I want to cure is the statement. I mean the question I put to Advocate Ferreira that there are other opinions that are different to his, which the first one is the opinion that appears as Annexure JF5 in the statement of I'm not sure which statement it is, or in the statement of Ferreira himself, actually.
The opinion of Marshal Mokgoro dated the 17th of August, attached to my statement as JF5. Of course, you must remember that
Sorry, I haven't asked the question. You give long answers, Mr. Ferreira. Can I just answer the question, so we can just relax, no, he's not. It's JF5. I think they've put it up on the screen.
Confused, Mr. Masuku. You referred to
Annexure JF5. We'll come back to the other one, the Mayema affidavit.
Okay. Oh, I see.
Statement, yes. So, Mr. Ferreira, just yes or no, do you accept that another prosecutor with significant experience has looked at the issues that you looked at and come to a different conclusion?
Yes.
A different conclusion to your conclusion?
That's correct, yeah.
Right. Now, the statement of, the opinion, the first opinion I'm putting to you is the opinion addressed to Advocate Sean Abrams by Advocate Nomvula Mokatla. You see that?
Yes, I see it.
Oh, sorry, I apologize. It's from Advocate MP Mokhatle. Soft. You see that, stated the 17th of August 2015.
That is correct, yeah.
Right. In paragraph 2 of that affidavit, or I'll say, that opinion, she tells us what she looked at. She looked at the evidence as contained in the case docket, the charge sheet of the state versus Mokgoro Jiba, the policy directives of the NPA, the provisions of the Act, and if you go down, she looked at the judgment, the affidavit of Boysen, and then she looked at the legal opinion of Ferreira and Van Eden. You see that? So she looked at your affidavit, at your legal opinion.
Yes, but she...
Sorry?
He did not look at the other stuff I mentioned in my at the meeting of the 22nd of July.
I'm not interested in that. I'm asking the question. And your answer is yes, she did look at the legal opinion of Ferreira and Van Eden. Am I right?
Yeah, your question was firstly premised on they looked at everything I looked at. So I was just advising you that he did not look at everything I looked, because the 22nd July, he doesn't mention any of those things that I mentioned at 22 July. So if you say he looked at my opinion, I agree, but you can't make the statement he looked at everything I looked at, because that is untrue.
Sorry, Mr. Ferreira. She looked at the legal opinion of Ferreira and Van Eden. You agree with that?
Yes, with that specific statement, I agree.
Yes. So when she wrote this opinion that she wrote, she looked at what you read and concluded.
No, he read my opinion. He did not look at everything I looked at.
I did not ask that question you're answering.
No, that's the question you asked.
No, that's not the question I asked. If you listen to the question, it might help to give a good answer. The question I'm asking you,
Let's not be rude to each other.
No, that's not being rude, ma'am.
Just let him answer the question, okay?
Yes, but I do not want an impression created that I'm being rude. I'm not being rude. It's not fair to suggest that I'm being rude.
I think language is
Or
very
perhaps,
important.
Don't ask your question to give the impression that you're badgering the witness. Okay?
Okay.
Don't do that. Yeah. Must be strategic when you answer your
Mr.
question.
Ferreira is a prosecutor. He understands this game. So I'm not being rude, ma'am. I'm actually being...
But I thought you said we're not going to dance.
No, we're dancing. And now the dance is intense.
You promised that we're not going to dance, and I believed you.
Yes, I then will return to the dance floor then. I apologize if I appear to be rude, Mr. Ferreira.
Apology required, thanks.
Now, what I'm putting to you is that when the opinion of Mohatle was prepared, she considered your opinion. You accept that?
Yes.
That's all I want. I mean, that's really all.
It's Mokgoro, and Mokgoro.
Talking about the soft one.
The soft one is the one that I'm talking
This
about.
opinion is by the gentleman.
Oh,
Am I
sorry,
wrong?
I apologize.
And yeah.
It's
Can
not
you
very
just
clear
use-
what the gender
yeah,
is
just call
there.
the name.
That's the issue, and I was trying to be very clear because you're busy saying she
When
didn't
is a
know
he,
it was
yes.
a he.
No, I apologize. Thank you for that. Now, of course, the whole point of this question is that he came to a different conclusion to the one that you came to in relation to whether or not there was reasonable evidence on which to prosecute Advocate Chiba. You agree with that?
Yes?
Right. Now, just so an impression is created that there are no, and of course we don't have the recent recent decision, so we can't really ask you about it. If the decision is not to prosecute, would you accept it as a bona fide decision reached by a prosecutor who has applied his mind to the law and the facts? There are no ulterior motives. Just like you, they've professionally engaged with the issues and come to the conclusion that you're wrong. Would you accept that?
I have to accept it.
Right.
But I won't accept I'm wrong. I will accept that they have a different opinion and they may feel very strongly about their opinion, which is different from mine.
Then, of course, they may be referred back to the affidavit of Maema. You accept that Maema has also reached a different conclusion to yours?
I haven't seen that affidavit, and I'm not sure whether that's an affidavit.
Sorry, it's a statement. Well, it's written affidavit, so I'll call it an affidavit.
Yeah, I don't think I've ever seen that affidavit. I don't know what it contains. So, yeah, I can unfortunately not comment on it.
It's sorry, that statement I'm instructed is in the docket of Advocate Chiba. You would have looked
That
at
statement, yeah,
Yes.
sorry, no, I thought it's a statement made for the General Counsel of the Bar. So, sorry, I was mistaken then.
No, I'm talking about that statement
Okay.
on the screen.
Yeah, I haven't seen it since a long time ago.
Yes, but generally, what I'm putting to you is that there are people who differ with you on your position in respect of Advocate Chiba.
I think you answered that question.
Yes, no,
Yes.
but then I'm closing down. I'm just shutting down the whole thing. You accept that?
I accept
And
that,
you
yes.
don't ascribe any motives other than good prosecutors engaged with the facts, the law, and coming to a conclusion different to yours. No
That's correct.
agenda to protect anybody.
No, I agree with you.
Just the last thing before I take instructions from What do you understand by prosecutorial independence?
I think prosecutorial independence is linked to prosecuting without fear, favor or prejudice.
Yes.
That the only factors you take into account is those facts in the docket and you prosecute on those facts, and that you do not prejudice people because of any bias or beliefs that you may have, and you do not prosecute people without any evidence. That's also an important factor. And then obviously that you do not favor certain people and either prosecute on their behest or do not prosecute them because you favor them. So in broad terms, I think that is what I believe.
Would you accept the proposal I'm going to put to you, that this prosecutorial independence is what would make the NPA a credible institution, feared by criminals and loved by the public?
Absolutely, yeah.
And that independence would be independence from both inside the NPA itself, so your supervisor cannot subvert that principle in relation to you.
I understand your question correctly, yes.
Yes.
Everybody should have the same focus.
Yeah.
Yeah, and everybody took the same oath of office, which, by the way, means you're only limited to the Constitution and the law.
Yes.
That's your guiding principles.
Right. So would you accept, and I put no further, it's just a principle. Would you accept the principle that it is not desirable for a prosecutor to be prosecuted for a prosecutorial decision that they make?
If that decision is not rational or justifiable and is actually the commission of a crime, no, you can't, because a prosecutor can't, in the execution of their duties, commit crime and get away with it.
You accept it as a principle that it's right, what I put to
As
you?
a principle, it's right, but if a prosecutor commits crime, he or she must be prosecuted.
Yes. Is there anything else? This would be the last issue that I deal with. Can we go back to the statement of my which paragraph? I'm just locating a paragraph that is relevant.
Madam Chair, may I just raise a concern? When they went through that statement, I saw the name of Advocate Smith in that statement. And I'm not sure that the docket statement of Advocate Mahema actually contains a reference to Advocate Smith. So I'm not sure that this is the docket statement that is being referred to. If they can page to page paragraph 3.
Sorry, Chair, because we're struggling to find that paragraph, and I don't want to detain us for long. It's something that we can argue at the end of it all. The statement is there.
In the judgment.
No, in the statement of my email. And the point has been made that there are other people who think differently to Mr. Ferreira. Mr. Ferreira, thanks very much. That's my cross-examination.
Thank you, Advocate Masuku. Yeah.
Advocate Ferreira,
Ferreira, examination. Yes.
with prosecutorial independence must come the fact that everybody must also be treated equally.
That is correct.
Right. Are you aware that under Advocate Jiba's watch, criminal charges were preferred against Advocate Glennis Breitenbach. Charge number 1 was perjury, charge number 2 was fraud, charge number 3 was obstructing and defeating the ends of justice, and then charges in claims of anything of which he was exonerated of just about everything.
There's not only criminal charges, also during the disciplinary inquiry.
Indeed. The issue came up in one of the memoranda, and I'm not going to take you to it. I think it's the Becker-Viljoen memoranda that they talked about. And on the question of declassification of documentation, there was a statement made that General Dramat would be dealing with that. Do you recall that?
No, honestly, I don't recall it.
It has some relevance, so let me take you to the statement for a moment. It's on page 138 of the documents. Under the first bullet point, it says the declassification of all confidential documents which are involved in the investigation. This is to be facilitated by the head of the DPCI, General Dramat, or the National Commissioner of SABC.
I see that, yeah. I don't know what General Dramat did because he was also removed at some other stage, so...
For the record, he was removed sometime in December 2014. But it then links back to what Nazir Kasim then finds later on. But the point I'm trying to make is, besides Mluli, charges against Barnard and Lazarus had gone on, and there's a criminal trial which is ongoing against them at the moment. Correct?
That is correct, and as far as I know, it's in a very advanced stage.
And that relates to the motor vehicle events in Talia.
No, not the motor vehicle charges that was here
No.
initially. That is other charges.
Oh, okay.
The ones where Advocate Arno Rousseau is prosecuting them in Pretoria Regional Court, but that is regarding the slush fund. That's the case that Gary Nel was busy with, and when he left, Arno Rousseau took over.
Right. So, you heard Advocate Nell's evidence on provisionally withdrawn. Do you agree with that?
Yes, I do.
Right. It was put to you that when Advocate Mokgoro gave reasons, there was no documentation that guided, or no policies or procedure that guided how that must be given. Isn't it implicit in how a prosecutor operates that when reasons are given, they must be rational, they must comply with the Constitution, they must at all times act within the principles of legality?
Absolutely, I agree with you.
You also heard Advocate Nell's evidence this morning about the attempts to find the letter of the 4th of December, which was the letter Advocate Mokgoro sent to Mr. Mudlong. What was the implications of not being able to find that letter, or not being able to get that letter?
Yeah, what we had to do is I actually issued a 205 summons against Ike Mutlaung, the attorney for Mr. Mdluli, in an attempt to obtain that document. And during that process, they pleaded legal privilege. I think Advocate Gerard Nel also spoke about the legal opinion that I wrote and the legal opinion that somebody else wrote. And I still believe to today there is absolutely no way that you can say that a letter sent by Advocate Mokgoro to the attorney for General Mdluli is legally privileged in the hands of the attorney. The reason why we wanted the letter is to see exactly when the letter was sent and how it was sent. And because we didn't have access to the content, the first time I actually saw that letter was in this document bundle when you showed me the letter.
So effectively, in the lack of evidence of that letter, you weren't able to proceed with the charges against Advocate Mokgoro.
Well, it's part of it, yeah.
it,
It's part of it, and I must just also perhaps say that when Advocate Abrams was appointed, he instructed us to withdraw the 205 against Ike Mutlaung. We were ready to proceed with it, and he would have pleaded legal professional privilege, and we would then be able to argue it before the magistrate, but we were prevented from doing that.
If when General Dramat met with Advocate Jiba and Advocate Mokgoro in August 2012. At that stage, the matter was far more advanced with much more charges, right?
That is correct, yes.
Right.
Sorry, Mrs. No, it's not advocate actually. When we address each other, it's Mr. and Mrs. and not advocate. So I think she does understand. I was trying to, for the record, when you mention an incident or an occasion, please clarify what you're talking about. You talk about a meeting with Mokgoro and Mr. Mokgoro and Ms. Jiba. What meeting? When was this? Otherwise, the record is not going to be...
You were referred to a letter in which detailed, the letter was the 12th of August 2012. It referred back to a meeting which General Dramat had with Advocates Jiba and Advocates Mokgoro.
That is correct, yes.
Right. And I put to you that the subject matter of that letter, which was referred back to General Dramat, saying he was satisfied with the explanation, he would go back and he would tell the SABC people to get instructions from prosecutors. Is that correct?
That is correct. But one must just mention that we never got feedback from Advocate Mokgoro who attended the meeting.
But between what that letter reflects is previous correspondence which General Dramat had addressed to Advocate Jiba in March and in April. And in March and in April, were there any requests made to you as the investigating officer to provide SAPS with prosecutorial instructions?
To me as the prosecutor, I think I was busy with Colonel Roelofse, and I was giving them advice on the China trip and the Singapore trip, but he would be in a much better position to say about that.
It was put to you that at the meeting of the 9th of December, which you were not present, Advocate Mokgoro, Advocate Mznyati and Advocate Breitenbach agreed that she would have to entail that there was further investigations to take place. Were you aware at that stage, did you subsequently become aware that Advocate Mokgoro, in a letter addressed to Advocate Jiba on the 12th of January 2012, recommended Advocate Breitenbach's suspension for misconduct? In other words, if you knew by January I was recommending her for suspension on misconduct, could you still then say I'm relying on her to do the work?
No, you can't.
Can I take you to the Boyson matter for a moment that was taken to you at length? You were not investigating the charges against Boyson. You were investigating whether there was a case of perjury against Advocate Jiba. Is that correct?
That is correct, yes.
In the course of trying to investigate whether there was a charge of perjury against Advocate Jiba, you were compelled to see whether she had just cause or rationally been able to take a decision on the evidence before her in respect of General Boyson. Correct?
That is correct. You must understand that there was a charge of perjury or an allegation of perjury. I had to look at that. That meant I had to look at her statement before Judges Gorvin, inter alia 24.5, and when I read that, I obviously had to look, when she says Boyson is implicated under oath in those statements, I had to look at those 4 statements and make sure that what she's saying is in fact correct or not.
Right. Now, for this charge of racketeering, it is a very serious charge. It has grave implications for somebody found guilty of racketeering, correct?
Absolutely.
The Poker Act, in fact, elevates it to such a level that you require the consent of the National Director.
Yes, it's only the National Director that may authorize that.
Okay. In the case of General Boyson, the enterprise was regarded as the Cato Manor unit, correct?
That is correct, yes.
And the financial gain was these annual awards which SAPS gave out, correct?
Which all state departments give to their personnel for good work.
And in your experience of how all personnel departments give it to good work, how do you know when you involved in this enterprise that somebody at the top is actually going to give you a financial award when you're competing with the rest of the country?
Yeah, that is true. You don't know. You must motivate, you write the motivation, and there's a panel that sit and make a decision whether you get a performance bonus or not.
And then I come to one last question. No, that's fine. Thank you, Advocate.
Thank you so much, Advocate Bauer. Thank you particularly to you, Advocate Ferreira. We thank you once more for your willingness to stay over and give us the opportunity to lead your evidence fully, so that we can also test your evidence, as it was well tested by counsel. Thank you so much. Yeah. In my vernacular language, I would have said likamuso. Yes, thank you. I think we can. Yeah, you may stand down always. Yeah. Thank you so much, and he doesn't have to travel. He doesn't have to travel. Yeah. Thank you. Thank you. That's it for the day.
Madam Chair, maybe as a reminder that we're convening on Tuesday.
Yes. Thank you so much, everybody, for your cooperation, for the work that we've done. Now we're reverting back to our normal time. No? 10 o'clock is not too late. Not too late. It's fine. Okay. Yeah, we won't sit on Monday, and we will resume, therefore, our hearings on Tuesday. 10 o'clock, same place, same time. Okay. Thanks, everybody.